Sometimes if you're a beat maker, producer that's starting out, it may sound like a quick $1,000 that they're offering you. But you don't want to be in a situation where you sell out all of the rights and then it goes on to become, some platinum hit and you're not making any other money off of it.
What's going down, everybody? My name is DJ Payne1 for BeatStars.com. Here with this is the first non-producer, non-manager, I believe that I've ever interviewed on this platform. She is a celebrated, award-winning lawyer, Cassandra Spangler. Welcome to BeatStars.
Thanks for having me.
I believe the website is cspanglermusiclaw.com. Let's just get that right out of the way for anybody watching wanting to get more information, specifically contact information. First things first, out of curiosity, do you have a musical background?
I do, yeah. I actually, I started out as a drummer. I never did it professionally, but I played drums for about almost 20 years. I don't really get to do it as much anymore as I would like to, but that is my background. And then from there, I kind of I worked at a couple indie labels, worked at a booking agency, worked at a record store, and then I went to law school and went into the legal side of it.
So is that what made you focus on entertainment law? Your background in music, having worked for the labels, played music yourself?
It is, exactly, yep.
I was hoping you would say yes, because otherwise those pictures of you with all the music instruments on your website was all a facade, but it's not. Okay, cool.
Yep.
Just to kick things off, why should a producer or beat maker, whatever they're referring to themselves as, get an entertainment lawyer?
Anytime when you're at the point where you want to make money, creating beats or producing is a good time to talk to a lawyer, because you're dealing with a lot of intellectual property, which is, it's intangible, and some of it gets pretty technical and pretty specific as far as the language and some of the producer agreements, and things that you should be asking for if you're leasing beats online. So I think it's a good idea from the start to at least consult with an attorney and get an understanding of, the different rights that are involved, the different income streams, so that you can make sure you're at least asking for the right things and that what you're getting is kind of within the range of what's standard.
Could you maybe give us an idea of what is standard, just in a nutshell, for the average producer out there?
Sure. Yeah, so there's kind of two separate sides of the coin, I guess. On one side, you have the sound recording, and that is going to kind of depend if it's something that's a major label release versus a self-release or an independent release. The royalties might be a little bit different. They might be structured a little bit differently, but you want to make sure that you are at least getting royalties on the sound recording side of it. So if it's something that's a major label release, you should be getting at least 3% royalties. If it's something that's a self-release, an independent release, it may be based on net income versus the other system that the major labels use. So you should be getting some percentage of net income. I would say somewhere between 15 to 25%, maybe more if you, as the producer, have more leverage than the artist. Maybe you're going to split it 50-50. But in any event, you should be getting something on that side of it. And then on the other side of the coin, you have the publishing, which is something that for some reason it's just very difficult for a lot of artists and a lot of producers to understand what the publishing is. But it's basically your part of the copyright and your income streams as a composer. So your contributions to actually writing the music. And you should always be getting at least 50% of the publishing on the finished song. The total publishing going to all of the producers. So if you have multiple co-producers, you all may be splitting the 50%, but the total going to the producers for publishing should never be less than 50%. So that's something that as a producer, as a beat maker, you want to make sure that you're always getting your 50% of the publishing on the finished song.
That's something that we deal with a lot as producers, and I know I talk with my colleagues a lot about our frustrations with artists approaching us and trying to buy that out, just even on a lease, sometimes on a exclusive license, but even still we're talking about $500 to $1,000 or something that personally I would never trade for it's basically my real estate in the song. And I guess I don't. What's your advice with how producers can communicate this to the people with whom they're working, so that they're not, being disrespectful or obstinate, but they're conveying, that it's not wise for them to take that, and it's not moral, and it's not really something that an artist should want to take from another artist.
Yeah, I think that's a really good way of putting it, that it's your real estate in the song, because it is. And I think probably the easiest answer to give if you're approached by an artist who wants to do a full buyout is just to simply tell them, we don't do any buyouts. So, they should understand that. I think probably the artists who are just starting out are probably the ones that are going to be asking to do a full buyout. But if they're with a label, even if it's independent label, they should understand that you want to keep your half of the publishing, because you don't want to be in a situation. I mean, sometimes if you're a beat maker, producer that's starting out, it may sound like a quick $1,000 that they're offering you, but you don't want to be in a situation where you sell out all the rights and then it goes on to become, some platinum hit and you're not making any other money off of it. So I think it's really important that, and the 50% is standard. So any artist or any label that isn't just starting should be aware of that, and they shouldn't take offense for the producer asking for their publishing.
And I'm glad you said that, because if it's standard, that means that you as a professional have seen time and time again consistently this 50-50 split, which is absolutely fair among creators, but oftentimes a strategy to manipulate a producer into, or a songwriter or a rapper, whoever, into giving up more than they should, is to lie and say, well, this is just how the industry works. And I think a lot of people do believe that, so it's good to have professionals clarify that. To piggyback, I don't know, all these animal metaphors, off of the last question, where should a producer look for an entertainment attorney?
I think it's always a good idea to ask other producers who if they have someone that they work with, that they're comfortable with, and then do your own research, because every lawyer, like every other person, has their own personality. And so you want to find someone who fits with your personality, find out what their rates are, find something within your budget, and find, because the goal, at least for me, is to build very long-term relationships with clients. So you want to find someone that is willing to work with you and build with you if you're just starting, and then as your career progresses, hopefully you stay with the same person. So yeah, ask around for referrals, that helps, and then just do your research online and kind of get a feel for the person.
Initially in the conversation, it sounded as though you were advising producers to work with entertainment attorneys, not simply so that they can provide a service, but so that you as the beat maker, producer, can learn about the legal side of the business. So in addition to that, what should a producer expect from an entertainment attorney?
I think it's always a good idea, right when you're ready to maybe, get started on BeatStars or a website like that. It's helpful and valuable, I think, to at least go and consult with an attorney, even if it's just for an hour, and kind of learn about what is publishing. What are royalties? What are the different kinds of leases that you might be interested in offering people, so that you kind of get a background knowledge and you can have more intelligent conversations with artists when they reach out, and you know what to ask for. So I think that's probably the very first step. And I have a lot of people that come into me and they're just starting or they're just getting ready to start, and we kind of come up with like a roadmap of what are some different steps that they should be taking when they have the budget to do it or they have the time to do it, so that at least even if you can't do it all right away, you kind of know, you can come up with a plan and a timeline to eventually get everything set up the way that it should be.
So beyond maybe an initial consultation with an attorney, what are some other resources producers can use to learn more about the legal side of the music business?
There's a really good book. I recommend it to everybody. It's called I always forget if it's Everything You Need to Know About the Music Business or All You Need to Know About the Music Business, but it's one of the two. The author is Donald Passman, and it's kind of like the Bible for music law. And he updates it, I think, every few years. I still sometimes refer to it. It's a really good resource because it gives you an overview on all the different types of contracts, the different types of rights. So if you hear a phrase or a word and you're not sure what it means, you can kind of just go in the index, look it up, and it's a really good resource.
So there was some recent confusion and frustration in the producer community about royalty-free sample kits, and just to get an expert's opinion and at least lay this one misunderstanding to rest, what does royalty-free mean?
It kind of varies. So I think that's another situation where you want to make sure you're really reading the fine print, because there are some websites where it's royalty-free if it's a non-commercial use. So if you're doing it for promotional reasons or you're not selling it, then it's royalty-free. There are other websites where it's totally royalty-free, meaning you just either it's free or you pay them, an upfront fee to be able to use this stuff, and then you can do whatever you want to do with it and not have to pay them any portion of the publishing or any royalties on sales and downloads and streams. But you want to make really certain that you're reading the fine print and the terms and that you're staying within the scope of whatever it is they're allowing you to do with it. And you also, you just want to make sure that, because some of those websites, it's like they have users that upload the free stuff, and then, you want to make sure that everything's solid with whatever website it is that you're using to get that stuff from, because it can lead to problems down the line.
Let's say you're not sure. What would the best course of action be?
I think you always want to kind of err on the side of caution, and if you're not sure if it's totally licensed and you're able to use it, you want to try to get something in writing that says clearly that you can, and you want to make sure that it's signed by the right person, which would be whoever created it. So this way, if the song blows up, and because if that happens, everybody who is involved is going to come looking for money. So you want to make sure that before that point, you have everything in writing. And it may come from the website. Maybe this just having those terms are enough. But I think it's always better to be safer and make sure that you have a clear written license to use it.
Yeah, I'm seeing that happening a lot more now with so many sound designers and so many producers out there that are creating sound libraries. Another big fear among producers is that their beats are going to be stolen and used without their permission, perhaps profited from without them receiving anything. And they always ask me how they can protect their work from being misused or used without their consent. What's some general advice you can give producers to either prevent it or to stay proactive if it does happen?
Yeah, I think two things. One, I would advise staying away from YouTube. I know a lot of producers put beats up on YouTube.
Oh, man.
Yeah, and that's I think what in my experience that's the most common place where they get stolen from, and then it gets kind of hard to track that back. So stick to websites like BeatStars where they have a system in place. Don't put it on YouTube. Even some producers put them on Spotify and stuff, and that you're just making it easier for people to take it and not credit you. And then the second really important thing is to register your copyrights. Because if you don't register the copyright before or at an absolute latest within 3 months of whenever you release that beat, it becomes a lot harder to sue, to bring a copyright infringement lawsuit if you ever need to. And I've seen situations like that where it's very clear that the beat was stolen, but the producer didn't register the copyright in time. And so, you lose out on a lot of money that you could be awarded if you had registered it in time, and it becomes very hard to find like a copyright litigator who will take the case if you didn't register it. So it's, you can register them in groups. The fee is $55 with the Copyright Office, and you can register, 20, 30 beats at a time if you want to. So it really is worth doing that before you put anything out online.
I know you already talked about some myths about the legal side of the music business. I think one had to do with license types. What are some other misunderstandings that you just see floating around the producer community that just won't die?
Sample. I mean, there's other misconceptions about samples. There's a lot of people who think that if
Here
you
we go.
use,
It's getting good now.
under a certain number of seconds, 7 seconds or whatever it is, that it's fine. And that's not actually true. If it's even 1 second, if they can identify it and prove that you used it, it's still copyright infringement. So there is no, it doesn't matter if it's recognizable, it doesn't matter how long the sample is, you can't use a sample without getting clearance. So that's a big misconception. What else? Again, about the licenses, exclusive versus non-exclusive.
All right, so to wrap things up, because I know you're dying out there in the heat. If a musician wants to contact you, whether they're a producer, whether they're a songwriter, recording artist, manager, how should they contact you and how should they prepare for that interaction?
I think email for me is usually the best way to start out with. Send an email with some information about yourself, what you need, and then we can kind of take it from there. Phone calls work too, but I think it's usually more helpful to send an email first, kind of explaining again what level you're at, what specific services you need. And even if it's just, again, a lot of people come in when they're ready to get started and they just do a general consultation. But yeah, I would say email, but you can also reach me on social media. You can call if that's better for you. And then I try to always respond to people within 24 hours. So. And
the website is cspanglermusiclaw.com. What are the social media usernames?
Yep, that's the website. Instagram is cspanesq. Twitter is cspanmusiclaw. Facebook is facebook.com/musicattorney. And then email and phone are all on the website.
Great. Well, thank you so much for your expertise and professional experiences. This is definitely a helpful interview to all producers at all levels, so I appreciate your time.
No problem. Thanks for having me.